Under the Advocates Act 1961, every advocate has the right of audience before any court in India. That right is not a privilege, it is not granted by the judge's mood.
Are you thinking a great senior advocate?
No, I have pain here, Lordship. That's why, Lordship.
You can say so many reasons. Call the police.
It is a statutory right. The power to commit someone for contempt of court, which is what the judge exactly did, which is what the judge was essentially invoking, is governed by Articles 129 and 215 of the Constitution and the Contempts of Court Act of 1971. That power requires deliberate, willful conduct that scandalizes or interferes with the administration of justice. Now, citing a judgment from a sister high court, that is Telangana High Court, which is what the council did, is not contempt. Asking a question, even an inconvenient one, is not contempt. Looking confused about what order a judge is asking for is not contempt. But apparently, somewhere in the judicial code, in the unwritten, unspoken, completely imaginary judicial code, not having a ready answer at the exact second the judge wants it, you may be disqualified. You may be sent to police custody for 24 hours. Good to know. Someone should update the law school syllabus for that. The Bar Council of India's letter to the Chief Justice made this exact point. The dignity of the court is not enhanced when a lawyer is made to beg for grace in the open court and is still sent to custody for a procedural lapse. They called it disproportionate. They called it as a chilling effect on young lawyers. And they are not wrong. Now, to be fair to our judiciary, and we must always be fair, this is not the first time a judge has, overexpressed themselves. We have judges who have asked women why they were out at night. We have judges who have made comments about what wives should cook. We have judges who have suggested that a rapist could avoid jail by marrying the victim. These are all real. These all happened in Indian courtrooms. But behind the actual scene is a deeply serious structural problem. India's judiciary operates with almost zero formal accountability for judicial conduct. Now, let me explain what actually that means in practice. To remove a High Court judge or a Supreme Court judge, Parliament needs a 2/3 majority under Article 124 Clause 4 and 218 of the Constitution. In the history of independent India, not a single judge has been removed through the process. Justice V. Ramaswamy faced this kind of impeachment in 1993 and survived because the ruling party abstained from voting. The same happened recently. The so-called in-house procedure, the Supreme Court's internal mechanism for investigating the complaints against judges, is confidential. It is informal and has no statutory backing. The Vice President also recently, even the former Vice President of India himself has said that it lacks constitutional basis or legal sanctity. So to summarize the accountability system, if a judge misbehaves, we write a strong-worded letter to the Chief Justice who may or may not tell the judge to behave better, and no one will ever know the outcome. Meanwhile, if a lawyer appears slightly confused in court, they can be sent to jail for 24 hours. Justice. The scales have never been more perfectly balanced. On 6th of May 2026, the very next morning after this incident took place, Bar Council of India Chairperson Manan Kumar Mishra wrote formally to the Chief Justice of India Surya Kant. He did not mince the words. He asked for institutional intervention. He asked for the withdrawal of the judge's judicial work pending review. He asked for the judge's transfer. He noted that incidents like this create fear in the minds of young lawyers. A lawyer appearing before a high court to argue a fundamental rights case watched his own fundamental rights to be violated inside the same courtroom. What India needs is not condemnation letters, what disappears into files. What India needs is a statutory, independent, transparent judicial conduct commission with real powers of investigation, real powers of suspension, and real public reporting. A mechanism where the judge's behavior in court can be formally reviewed without requiring a two-thirds parliamentary majority to act. Other democracies also have it. The UK has the Judicial Conduct Investigations Office. The US has a state level Judicial Conduct Commission with the power to censure or suspend or even remove the judges. Australian constitution also has the same, a judicial commission. India has a phone call and a prayer. A judge is not a king. A robe does not make you untouchable. A gavel is not a weapon. The courtroom is supposed to be the one place in this country where power cannot bully the powerless. Where a young lawyer with good argument has the same standing as a 30-year-old senior advocate. Where the law, not the judge's mood, decides what happens next. Now, what happened in that Andhra Pradesh High Court on 5th of May was a failure of temperament. But what allows it to keep happening in court after court, year after year, with nothing but a quiet transfer as a consequence? That is a failure of the system. If you agree that the India's courts need if you agree that India's courts need real accountability, judicial accountability, not strongly worded letters, not internal inquiries that nobody ever sees, share this video. Because the people in that courtroom who stayed silent were afraid. You don't have to be afraid. Thank you all. Thank you very much.